Introduction to business law. Business law is a broad area of law that governs the formation, operation, and dissolution of businesses. This field encompasses various legal aspects that affect commercial transactions and organizational structures. Understanding business law is crucial for entrepreneurs and managers to ensure compliance and mitigate risks. Sources of business law. Business law originates from multiple sources, including statutes, common law, and international treaties. Statutes are laws enacted by legislative bodies, providing specific regulations for commercial activities. Common law, developed through judicial decisions, creates precedents that guide future rulings. Legal systems and business. Different countries operate under distinct legal systems, primarily common law or civil law, which impact business operations. Common law systems rely heavily on judicial precedent, offering flexibility but sometimes less predictability. Civil law systems, conversely, are based on codified statutes, providing greater certainty but less judicial interpretation. Contract law fundamentals. Contract law forms the bedrock of commercial transactions, governing agreements between parties. A contract is a legally binding agreement that creates rights and obligations enforceable by law. Understanding its principles is essential for businesses to create valid and enforceable agreements. Elements of a valid contract. For a contract to be legally binding, several essential elements must be present. These typically include an offer, acceptance, consideration, intention to create legal relations, and capacity of the parties. Absence of any of these elements can render a contract unenforceable. Offer and acceptance. An offer is a clear and unambiguous proposal made by one party to another, indicating a willingness to enter into a contract. Acceptance is the unconditional agreement to the terms of the offer. Both offer and acceptance must be communicated effectively between the parties for a contract to form. Consideration and capacity. Consideration refers to something of value exchanged between the parties, which can be a promise, an act, or a forbearance. It is the price for which the promise of the other is bought. Capacity refers to the legal ability of parties to enter into a contract, meaning they must be of sound mind and legal age. Legality and form. For a contract to be valid, its purpose must be legal and not against public policy. Contracts involving illegal activities, such as drug dealing or fraud, are void and unenforceable. Additionally, some contracts require specific forms, such as being in writing and signed to be enforceable, particularly for real estate or guarantees. Vitiating factors in contracts. Vitiating factors are elements that can invalidate an otherwise valid contract, making it voidable or void. These include misrepresentation, mistake, duress, and undue influence. When a vitiating factor is present, the innocent party may have the right to rescind the contract. Discharge of contracts. A contract can be discharged or brought to an end through various means. These include performance, where both parties fulfill their obligations, and agreement, where parties mutually agree to terminate the contract. Other methods include breach, where one party fails to perform, and frustration, where unforeseen events make performance impossible. Remedies for breach of contract. When a contract is breached, the innocent party may seek various legal remedies. The most common remedy is damages, which aims to compensate the injured party for their financial losses. Other remedies include specific performance, requiring the breaching party to fulfill their contractual obligations, and injunctions, preventing certain actions. Types of business organizations. Businesses can be structured in various legal forms, each with distinct implications for liability, taxation, and management. Common types include sole proprietorships, partnerships, and corporations. Choosing the appropriate structure is a critical decision for any new venture. Company law basics. Company law governs the formation, operation, and dissolution of corporations, which are distinct legal entities. Key concepts include corporate personality, limited liability for shareholders, and the roles of directors and shareholders. This area of law provides the framework for large-scale business operations. Agency law principles. Agency law deals with the relationship where one person, the agent, acts on behalf of another, the principal. The agent's actions within the scope of their authority bind the principal. This relationship is crucial in many business contexts, from sales representatives to corporate executives. Tort law in business. Tort law addresses civil wrongs that cause harm or loss, leading to legal liability for the person who commits the tortious act. In a business context, common torts include negligence, defamation, and trespass. Businesses must be aware of tortious liabilities to avoid legal disputes and protect their reputation. Introduction to labor law. Labor law, also known as employment law, governs the relationship between employers, employees, trade unions, and the government. Its primary purpose is to protect the rights and interests of workers while also setting boundaries for employer conduct. This field covers a wide range of issues, from hiring to termination. Employment contracts. Employment contracts define the terms and conditions of the working relationship between an employer and an employee. These contracts typically cover aspects such as job duties, working hours, remuneration, and confidentiality clauses. Both written and implied contracts are legally binding, though written contracts offer greater clarity. Employee rights and responsibilities. Employees possess fundamental rights, including the right to fair wages, safe working conditions, and protection against discrimination. Simultaneously, employees have responsibilities, such as performing duties diligently, adhering to company policies, and maintaining confidentiality. These rights and responsibilities form the core of a balanced employment relationship. Discrimination in employment. Labor law prohibits discrimination in employment based on protected characteristics such as race, gender, religion, age, and disability. Employers are legally obligated to provide equal opportunities and prevent harassment in the workplace. Anti-discrimination laws aim to foster fair and inclusive work environments. Termination of employment. The termination of an employment contract can occur through various means, including resignation, dismissal, or redundancy. Labor law dictates specific procedures and notice periods for termination to ensure fairness and prevent wrongful dismissal. Employers must have valid reasons for dismissal and follow due process. Health and safety at work. Employers have a legal duty to ensure the health, safety, and welfare of their employees at work. This includes conducting risk assessments, providing necessary training, and maintaining safe equipment and premises. Compliance with health and safety regulations is paramount to prevent accidents and occupational diseases. Corporate governance principles. Corporate governance refers to the system by which companies are directed and controlled. It involves a set of relationships between a company's management, its board, its shareholders, and other stakeholders. Good governance promotes transparency, accountability, and long-term sustainable growth. Environmental law in business. Environmental law regulates human activities that affect the environment, aiming to prevent pollution and promote sustainability. Businesses must comply with regulations concerning waste disposal, emissions, and resource management. Adhering to environmental laws is crucial for corporate social responsibility and avoiding penalties. Introduction to intellectual property. Intellectual property (IP) refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. IP law protects these creations, granting exclusive rights to creators or owners. Understanding IP is vital for businesses to protect their innovations and brands. Copyright law essentials. Copyright law protects original literary, dramatic, musical, and artistic works, including software and architectural designs. It grants the creator exclusive rights to reproduce, distribute, perform, and display their work. Copyright protection typically arises automatically upon creation, though registration can offer additional benefits. Trademarks and patents. Trademarks are distinctive signs, designs, or expressions that identify products or services of a particular source from those of others. Patents protect inventions, granting the inventor exclusive rights to make, use, and sell their invention for a limited period. Both are crucial for brand recognition and technological innovation.